We're about to start, guys. We're going on the record on cause number DC 1918138, Coleman Fear, I think that's how you say it, versus Seal, which has been posted under Rule 76A. Counsel, make your appearances.
Robert Bogdanovich for the plaintiff.
Jesse Cromwell for defendant Chris Chadwick.
And let me just, I'm sorry, Mr. Fuller.
Hugh Fuller for QMP Investments and Michael Morales. And as we said, Your Honor, we will not be taking a position in this. We had no objection to the request of relief, and I am here only to observe.
All right. I want to make sure this is a hearing that is open to the public, and the public is allowed to participate in this hearing. Is there anyone here? There's a number of interns here. I don't believe there's anyone else here on any other matters. Is anyone here else besides the counsel that just stated they were? Is anyone else here to object or to provide their input about the sealing? Okay. No one has stated so. And Ms. Pinson is on the record, but she's not able to post. So I'm going to just ask her to text me. Ms. Pinson, has anyone requested to appear at this hearing besides the attorneys? She texted me, and she's texted me. She said no one else has requested to appear at this hearing. I understand that there has been posting for this motion to seal. Is that correct? If you can describe how that occurred.
Yes, Your Honor. What we did was we sent a notice to Dallas County. I'm pulling it up, wherein we requested that the notice of hearing be publicly posted in accordance with the rule. And that was sent via email to Stephanie Granberry. I'm sorry, it was sent to the clerk in Dallas County on the 27th of April. And then on the 28th, Stephanie Granberry at Dallas County responded and confirmed that our motion to seal notice of hearing was uploaded to the Dallas County website and posted to the public that day.
Court finds there's no member of the public here that wishes to speak about the motion to seal. Let's go ahead and start our argument. If anyone does show up, Ms. Pinson, if anyone does show up to request to appear, go ahead and add them to our call, to our Zoom call here. And otherwise, please proceed with the motion to seal. Mr. Bogdanovich.
Yes, Your Honor. As you know, this is a motion to seal a portion of what has been previously filed in this case. In particular, it is the exhibits that were attached to defendant Christopher Chadwick's answer, special appearance, etc. There were counterclaims. And, we're looking at Rule 76A. And in this case, Your Honor, court documents can be sealed if a specific, serious, and substantial interest clearly outweighs the presumption of openness in the courts, and any probable adverse effect that sealing will have upon the general public health or safety. None of that applies here today, Your Honor. The documents attached to that pleading that we're looking to seal, and again, I'll reiterate, of course, this was jointly filed by both parties, and Mr. Fuller, the third-party defendants counsel, does not oppose this relief. We're just looking to seal those exhibits because they contain tax returns, business valuations, and sensitive financial data related to the underlying business in this case. And none of that information would have an effect on the general public's health or safety. In fact, one would say that it may qualify as a trade secret because the information contained there that's derived and utilized in preparing the tax returns is financial data that shows the profitability, et cetera, of Cardiovascular Labs of America, a healthcare company. And so we're just asking the court to seal that exhibit so that that sensitive data is not available for the public viewing. The rest of the pleadings, of course, in the case itself should not be sealed, and we're not asking for them to be sealed. And so I believe, Your Honor, it would be proper in this case. The court has the discretion to do this, to seal those exhibits, so that they're not publicly available for viewing.
Okay, let me hear from other counsel on this.
Your Honor, I think he's covered the basis of the motion. There's not much to add there. It's just proprietary financial information, and we agree with the motion.
Okay. Let me hear from the other counsel.
No objections, Your Honor.
Okay. And let me make sure that I have you submitted a proposed order for this?
We have, Your Honor, but according to the rule, just to be, make sure it complies with law, while we have something that's kind of a general format, what we just have to do is insert specifically what the court's finding is as to the justification for sealing it, which again, if we revise that order and sent it back in, I believe the court's basis would be that this information complies with Rule 76A, and since it is financial, reputational, or otherwise, so there's a case out of the Dallas Court of Appeals that uses that phrase, it should be sealed. And so we would submit that to Your Honor for signature if that would be the basis by which you would seal this.
Please submit the order as indicated, and go ahead and, just because of the nature of what's going on right now, go ahead and email that to my court coordinator as well as filing the order with the court.
Yes, sir.
And anything else we need to talk about today?
No, Your Honor.
Let me just look at something real quick. So this case, is it currently set for trial?
That is a good question, Your Honor. I can check. I do not know.
Yeah, I don't think it is set for trial, but all the attorneys have made an appearance in the case, correct?
Yes, Your Honor.
When do you guys want to set this for trial?
Oh,
We can get
you're
a setting this year.
coming up soon. We're hopeful that I believe is it May 29th, Rob? Does that sound right? So
We're mediating, yes.
yeah, in the next 2 weeks we'll have a mediation. So we're hopeful that will help get this case resolved. I would think if that doesn't take place, I think there's probably still some significant amount of depositions that would need to be taken amongst the defendants, well, the third-party defendants and plaintiff regarding his claims. And I think we need at least 6 months from today, maybe even a year.
Do you want to shoot for next summer?
Yeah, I think that would probably work if that sounds okay to you, Rob.
And I would think that the court would probably not even be able to get to us this year just because of what's going on. So even if we would ask for one, it just probably doesn't make sense. So I would agree, Your Honor, because rather have something that we could hopefully, look at and go to trial on, particularly on a first setting. So if that's what the court believes is appropriate, we'll go with it.
So let's, Rhonda, go ahead and set this at the end of next May. All right. We'll go ahead and set, and do you, who did you want to use as a mediator? Or do you
Your
have-
Honor, we're having Chris Nolland mediate the case.
Great. Okay. Very good mediator.
Great.
Okay, great. We'll go ahead and make sure, have Chris Noland, Nollan, be our mediator if we haven't already done that, and set it for the end of May. We'll get you a trial notice and a mediation notice out as soon as possible. Anything
Thank
else,
you, Your Honor.
guys?
That is all, Your Honor.
Anything else, Mr. Cromwell?
No, Your Honor. Thank you so much for your time.
Mr. Fuller?
No, Your Honor, and thank you for your discretion in allowing me to appear virtually in my Hawaiian shirt.
Okay. Have fun fishing tomorrow, guys, and
Your Honor.
you guys be safe, okay?
Thank
Thank
you,
you.
Judge.
All right, you have a great day.
You too.
You guys are excused. Mr. Cromwell, you're excused.
Yeah, I'm having a hard time for some reason. Here we go.
All right, so let me chat with you guys real quick before I let the next case in. Michael, why don't you go ahead and I've kind of remembered what I was going to do with Samir. So you're going to be, your summary judgment's going to be that JTJ Solutions versus Eli Global that we just heard. I told you about to take notes on. And so I hope you took really good notes. You will be able to, I think all of that was on YouTube. Oh shoot, this is.
We're still on, Your Honor.
Sorry.